In episode 9, we talked about Richard's writ of habeas corpus, and we left with a bittersweet ending. I was happy. Judge Bennett granted Richard relief based on a Brady violation. The fact that the prosecution hadn't revealed 2 witnesses that could potentially corroborate Richard's story. The thing is, I talked to Richard on a monitored phone line, and I have to wear regulated undergarments if I want to see him in person. So, spoiler alert, Richard is still in prison. But why? What happened between the time that Judge Bennett so forcefully declared that there had been a Brady violation and now? The state appealed Judge Bennett's decision, and that appeal was heard by a 3-judge panel at the United States Court of Appeals for the Fourth Circuit. That appeal is what this episode is all about. You're going to hear audio from the hearing throughout the episode. I didn't sign a waiver saying it wouldn't be broadcasted, and there was no legal warning implying it couldn't be used. Actually, it's available for anyone to download on the internet. I'll put a link to it on the Convicted Podcast website. To try and keep the mid-episode interruptions to a minimum, let's talk about our first sponsor. I have the SeatGeek app on my phone, and it's by far the easiest way I found to shop for tickets. I can be anywhere, and with just a few taps, I can instantly find seats. I actually just used it to buy tickets to Anastasia. SeatGeek is designed to make your ticket buying experience easier than ever. It saves you time and money by searching multiple ticket sites to compare prices and find amazing deals. And to get the most bang for your buck, SeatGeek grades every ticket based on value to help you immediately identify the best seats that fit your budget. Plus, every purchase is fully guaranteed, so you can shop for tickets on SeatGeek with confidence. Make SeatGeek your go-to app for finding the best deals on every type of ticket, from sports and concerts to comedy and theater. Best of all, my listeners get $20 off their very first SeatGeek purchase. Just download the SeatGeek app and enter promo code CONVICTED today. That's promo code CONVICTED for $20 off your first SeatGeek purchase. We're going to talk about the appeal at the Fourth Circuit and ultimately why Richard is still incarcerated. In the end, this episode left me very heavy-hearted. I'm Brooke, and this is episode 10 of Convicted. The appeal from the state on Judge Bennett's ruling for Richard Nicolas to receive a new and potentially fair trial took place on March 22, 2016. That's around a year and a half ago. He was arrested in 1996. That's 20 years of bouncing around the court system.
All right, the next case we're going to hear this morning is Nicolas versus Maryland Attorney General.
In this courtroom, there were 3 judges, Judge Niemeyer, Judge Motz, and Judge Cogburn. Judge Cogburn was a designated judge, which means he was appointed to this case, even though it's not his usual district. Arguing for the Attorney General of the state of Maryland was Mr. Edward Kelly. Mr. Kelly was also the opposing counsel in the habeas hearing by Judge Bennett.
Good morning, Your Honors. May it please the Court, Edward Kelly on behalf of the appellants and, of course, indirectly the victims in this case.
And, of course, on behalf of Richard, was Jeff.
May it please the Court, Jeff Garrett with my colleague Matt Reinhart. We are appointed by the Court and we are privileged to represent Mr. Richard Nicolas today.
I asked Richard if he'd been present for this hearing, and he told me regrettably that he had not been. Apparently, inmates aren't permitted to attend appellate arguments in Maryland. I asked Mr. Garanther if he could set the scene for me and tell me what the courtroom was like on that day.
So we get there, and we're the last argument, so that's actually kind of nice because you have the benefit of sort of getting into the rhythm the judges are in that day. So we saw 3 other arguments before theirs. We were sitting with Mary and her boyfriend and Art Cheslock, who had been one of Richard's lawyers, who you've probably spoken to, who's stayed in very close touch with Richard and has been a tremendous friend and former counsel to him. And Art was there with his wife, in fact, and Matt and I. So we had our little team, and we were sitting together. We're watching the other arguments. I then see the judges, particularly, again, Judges Niemeyer and Motz, give Tad a pretty hard time in his argument. And that's sometimes a barometer if you're trying to read tea leaves, to mix metaphors, but not always. So I'm feeling pretty good when I get up there to begin arguing for my part of it.
As the representative of the appellants in this case, Mr. Kelly was invited to speak first. He told the court that the best place to start was at the habeas hearing held in front of Judge Bennett. He shares with the three-judge panel a quote that we are all familiar with.
Judge Bennett, in the process of lecturing a much younger version of myself, states, "I don't know what the facts are of this case. I am not the jury of this man's guilt or innocence. But I know a Brady violation when I see one, and this is pretty clearly a Brady violation." If I can repeat and paraphrase, I don't know what the facts are of this case, but I know a Brady violation when I see one.
Mr. Kelly says that this is the very root of the problem with Judge Bennett's ruling. He's biased against potential Brady violations, and he had prejudged this case without knowing the facts. He argued that Judge Bennett's history of in-camera reviews requiring prosecutors to divulge any potential Brady material is evidence supporting that bias.
Judge Bennett's comments at the two federal habeas hearings in this case make clear that he has a high threshold for Brady and a contempt for Brady violations.
It seemed to me like Mr. Kelly had contempt for Judge Bennett. He pointed out that he'd been lectured by him, and he had contempt for the judge's process of thoroughly investigating potential Brady violations prior to hearings. I apparently was not the only one to think he was coming across as a little harsh.
You know, I speaking just for myself, I don't think it's really a great strategy to attack the district judge.
That voice was Judge Mott's. A little bit of history. Judge Diana Mott's was the first woman from the state of Maryland to be appointed to the Fourth Circuit, and she was the second woman to be appointed to the Fourth Circuit ever. Mr. Kelly goes on to talk about how Judge Bennett's approach to Brady was his downfall to appropriately ruling on the habeas. He said that the state court had found in a factual finding that, at best, the two witnesses conflicted with Richard Nicolas's telling of events. I don't think that's true. But because it was deemed a factual finding by the state court, my opinion and the opinion of Judge Bennett are unimportant. Legally, we should defer to the state court's factual finding in a federal habeas hearing.
A factual finding is presumed correct unless rebutted by clear and convincing evidence. Factual findings are judged based on the evidence presented in the state court proceeding. The federal court can't simply replace or substitute its judgment for a state court factual finding.
The state court had found that the failure of the prosecution to turn over the witnesses was not a violation of Brady because the witnesses' testimonies wouldn't be useful to Mr. Nicolas. Just so you know, that's not generally a done thing. It's not only about how useful the witnesses would have been in court, but how they could have benefited the defendant overall. Judge Mott seemed pretty perplexed by this reasoning. It wasn't something she had seen before either.
I mean, I just, before this case, I have never seen the state assert that particular claim. Well, it's always been about materiality because at least the cases that I've read, and I think the Supreme Court cases, don't say that the evidence has to be admissible, which is what you seem to be saying. It had to be, in your case, it had to come within one of the state's procedural rules. Because I thought the theory was that anything that was helpful to the other side's case, that could lead them to witnesses, or could assist them in cross-examining, or to lead to a fruitful area, would be regarded as favorable. And I just hadn't seen the kind of analysis that you've put forth with respect to favorability.
It doesn't matter, Kelly seems to say. It's not important why the state court found the way it did. What does matter is that it was a reasonable factual finding and it was disregarded by the district court. Judge Niemeyer joins the conversation, begging the question exactly how much deference does the federal court give to the state court in a matter like this? What exactly is it that makes something relevant or useful to the defense?
The question, I suspect, comes down to these state judges looked at this and made a call about it. And the question is, what is a federal court's role after you have that, and how much deference? And I don't know if the state judge is totally right or not, or whether I would have let them have it and ordered it so they could at least look at it and have it be impeached. The statements, that is, but the standard is pretty high for a federal
Your Honor.
court.
The judge goes on to point out that they're using language like useful and material, but the definition of Brady says that the evidence has to be exculpatory. Exculpatory literally means to clear someone of guilt. So the implication is, yeah, maybe the witnesses would have been helpful, but is it going too far to say that they would have cleared Mr. Nicolas of guilt? I have a problem with that, and that problem has stuck with me ever since I found out about the witnesses. This is purely my opinion. When Richard Nicolas was at his original trial, he was supposed to have the presumption of innocence, and the burden was supposed to be on the state to prove his guilt. The jury considered the evidence presented to them, and then it decided that Richard no longer had that presumption, and that he was guilty. Being a guilty man changes the burden, because now it's his job to prove that he was wronged. The state relieved themselves of needing to prove anything, because that's no longer their job. The point that I'm getting at is that in all these appeals and hearings and arguments, Richard Nicolas has the burden of proving he was wronged, and it was a heavy one. When the burden of proof that the witnesses were not useful was the duty of the state, instead of satisfying their burden, they chose to hide it. It seems like making an unethical decision was a reward for the prosecution, an easier conviction, and relief of the burden of proof. We could never know what the effect of those witnesses on the jurors would have been when making a decision about a man with the presumption of innocence, because the witnesses weren't revealed until that legally innocent man was determined a legally guilty one. Now, the validity of those witnesses' testimonies are being dissected and examined and scrutinized by courts not responsible for determining innocence or guilt. But yet, they're using their assumptions of how the jury would have reacted to make decisions. That doesn't feel like justice. It feels like...
This was not a fair trial.
Mr. Kelly goes on to talk about the lack of favorability to the convicted Richard Nicolas by the witnesses.
What we are left with are the statements of Benson and McKenzie, which describe this specific event, which involves this car in a cul-de-sac, an individual that has no relation whatsoever to the facts of Asia being shot and killed at a totally different location across a major highway. So we didn't hear from Mr. Benson. We didn't hear from Ms. McKenzie. We didn't hear from an acoustic expert. So there was no connection to make these particular statements favorable. But, the favorability
of course, the
analysis...
reason you didn't hear from them to begin with in the trial was because the state never revealed this evidence to the defendant, correct? So, I mean, all that evidence could have come in, or the district court or the trial court could have concluded that it was or is not admissible, but there was never that shot.
At this point in the hearing, I was feeling pretty hopeful, like Judge Motz might just be a voice of clarity in a case that's been anything but clear. As the time for Mr. Kelly's oral arguments began to dwindle, he goes in a different direction. He rehashes the details of the crime, including the circumstantial pieces of character assassination that were used by the prosecutors in the 1997 trial.
And I would submit, this wasn't a close case. I mean, this was a case that was tried over 3 weeks. The state put on a powerful case. Remember, Mr. Nicolas was at the scene of the murder. The murder occurred in his car. The story that he explained to the police and explained to trial was that he got followed by a rogue road rage driver, and instead of driving his car to safety, he ends up driving his car down a desolate road, Bowley's Lane, pulls over to the left side of the car, turns his engine off, turns his lights off, puts Asia in the most particularly dangerous position. Then he emerges from the car. The shooting occurs. The driver drives off. Mr. Nicolas, a trained emergency medical technician, doesn't even check on his daughter's condition before he goes on foot.
Is his statement of the case that his driver's door was open and the shooting occurred through the front door?
Through the passenger door with the window down.
Well, I thought she was shot on the left side of the face.
That's correct.
But she turned her head, certainly. I mean, isn't that what?
I guess that was the theory.
Because she was looking at the shooter.
Of course she turned her head. What 2-year-old wouldn't look out the window to see an apparent commotion? She was shot in the left eye, and there was no angle in the route that the bullet took before it lodged into the back of her head. The shooter was likely level with her. Are the issues I just stated important at this particular hearing to determine if Judge Bennett's ruling was appropriate? No, they're not. But neither was the retelling of a wishy-washy version of Richard's story by Mr. Kelly. I think it was like telling someone not to think about a pink elephant. Once the image has been conjured, it's almost impossible to disregard it. My hope that this hearing would be a pathway to a fair trial started to dwindle at this point. Then, another voice of reason chimes in with what I've been saying all along. The witnesses heard a sound consistent with a gunshot at the time Richard Nicolas said a gun was fired. That feels pretty important to the outcome of this case.
Their argument is that it places the gunshots at 10 o'clock, which undermines your whole case.
Well, only if those witnesses would testify to that effect. We have no evidence whatsoever that those witnesses would actually testify to something inconsistent with their statements.
Statements indicate a 10 o'clock gunshot.
Right.
Sound.
But it can't be divorced from what the witnesses were actually visualizing.
You were saying couldn't find out how it helped their case. That's the argument they make, is that it places the gunshot sound, if it is that gunshot, at 10 o'clock.
And then Mr. Kelly's time was over, and it was Jeff's turn. Right after the break. I was recently at a conference, and while I was there, I was fortunate enough to meet Chelsea, the creator of one of my new favorite podcasts, Deliberations. I was wearing a dress I had gotten at ModCloth, and it had newsprints of cats on it, and best of all, it had pockets. I'm always self-conscious about what I wear, so when Chelsea asked me about the dress, I told her that it had come from ModCloth, and it was super comfortable. Their signature line of apparel comes in a full size range, from extra extra small to 4X, so it's never been easier to find your perfect fit. If you're like me and need a little outfit advice, you can reach out to their amazing team of mod stylists for free sizing, fit, and styling help. Yesterday, when I was listening to episode 4 of Deliberations, I was stunned. My ModCloth dress had made such an impression on Chelsea that she mentioned it in her own podcast. To get an outfit you love, go to modcloth.com and enter promo code CONVICTED at checkout to get 30% off your order of $100 or more. That's modcloth.com and enter promo code CONVICTED to get 30% off your order of $100 or more. Snag your next style obsession at ModCloth. Jeff begins with his own recounted version of Richard's trial. I'm going to let him explain it. He did a good job.
This was a horrible crime. A young girl, a child, died brutally. Her family understandably wanted justice. The whole city wanted justice. If you remember back to the Spencer v. Roxbury case, it was 1991 Annapolis. It was known all throughout town. It was a big deal then. Well, this event in 1996 Baltimore City was an even bigger event, more vulnerable victim, not just a brutal beating as in the Spencer case, but a killing. And an entire city wanted justice. So that there was tremendous pressure on the two then young prosecutors doing this case. There can be no doubt about it. It's made obvious from the letters, now part of the record, that they sent to the medical examiner and to the lead detective, thanking them for winning the case by placing, as you just said, Judge Niemeyer, the crucial issue, the time of death 2 hours earlier than the defendant said it happened. In this entirely circumstantial case against the defendant, the only issue was when that death occurred. Mr. Nicolas said it happened between 9:45 and 10 o'clock. The state left with only weak circumstantial evidence, such as he didn't seem as upset as he should have been, as if there is a prescribed way for a man to react, maybe a man who holds in his emotions, maybe a man in this case, and there was clear evidence to this at the trial, a man who's got a serious stammer and stutter. He can't get out a word without calming himself down, without slowing down everything about himself. Otherwise, the upsetting circumstances will not allow him to say anything.
I'm usually good at reading people, and so at this point, if I had to guess where the judges stood, I would guess Judge Motz was in favor of letting Judge Bennett's ruling stand, and that Judge Niemeyer was against it. The other judge, though, he hasn't said anything, and I can't see his body language, so I just don't know. The fact that I can't tell bothers me a lot. But then I imagine Richard Nicolas in his cell in Cumberland, Maryland, while a room full of people are deciding his fate at a courthouse in Virginia. I wondered how Jeff must have felt. He was in the room, seeing the judges, and gauging his chances. So I asked him, what was it like?
But it became clear pretty early on that Judge Niemeyer in particular had a view that this wouldn't have made a difference to a jury because the state would have been able to show that the gunshot came from this other event that was happening. What really was discouraging to me, though, was I went into it thinking, well, we may not get Judge Niemeyer, who's a fairly conservative judge. If I remember my history right, a Reagan appointee. He was a lawyer here in Baltimore at what was then Piper and Marbury, now called DLA. Very successful lawyer in private practice, has been on the bench forever in the Fourth Circuit until the last, I would say, 8 or 9 years, since the beginning of the Obama administration, was known as maybe the most conservative court in the land, covering, as it does, Maryland, West Virginia, Virginia, North Carolina, and South Carolina. So when I was a prosecutor, that was a good place to be. I don't think I ever lost a case on appeal as a prosecutor. As a defense lawyer, it was a much tougher place to be. So I have Niemeyer, who's very conservative, but then I have Diana Motz, who was really at the vanguard of turning this into a more progressive court. There are now many more liberal judges on it, but there's no question that Judge Motz, a Clinton appointee, is a more progressive judge, and I felt good about having her. I didn't know much at all about Judge Coburn or Cogburn, including how to pronounce his name, but I thought, you know, if I get Motz, she can persuade Coburn to go along with her, and we'd have 2 of the 3 judges on the panel.
The court, Judge Niemeyer, acknowledges that the witness's time frame is more aligned with Richard's than the state's. However, he then goes on to say that he doesn't think anything else about their statements matches Richard's version of events. The witnesses saw some other car in a cul-de-sac on the other side of the building, and they were consistent about that. If Judge Bennett was being accused of having predetermined judgment, I think the same could be said for Judge Niemeyer. He spent several minutes talking about the distances and directions, and I just kept thinking, what would the jury have done? I learned in college that the human brain wants to make sense of things. So if someone sees a light flicker and hears a sound at the same time, the human brain will naturally associate the 2 sensory inputs because it makes sense. Except sometimes the sound is coming from across the road and the flash is coming from a cul-de-sac on your side of the street.
He said, and I saw this flash of light and heard a bang, but I didn't know what it was. I mean, I didn't know if it was, I don't know what it was like. It turned my head and looked like, I guess, when it was really happening, whatever. So you saw a flash of light and a bang. You heard a loud noise, right. And then, of course, the dome light came on and so forth. But so I mean, he's pretty direct head on, and he describes the car, he describes the color of the car, he describes the 2 people in the car, one in the back seat, one in the front.
He's not going to change his mind. He's made his decision. But the problem comes when he starts to change the mind of the other judges. And it feels like that might be starting to happen.
Your point is that both of these people heard a noise, and one or both of them said it sounded like a gunshot, and then they both looked around to see where it would be coming from. But they didn't necessarily say, oh, they couldn't say where the sound came from. But the only thing they saw that was a likely candidate of source was this car.
Correct. Yeah. Of course they're looking for where it came from.
Mr. Benson testified there. when he was giving his statement, he said he saw activity down there in this car parked near the trucks. And by then, he was not attracted to that by the bang. And as he was looking, he saw a flash and heard a bang.
I asked Jeff what it was like for him at this point in the hearing. I wanted to know if he had the same hope that he had in the beginning.
But then after Niemeyer started firing at me, then Judge Motz started piling on in a way that I was familiar with because I know her, and didn't have the sense that she was doing it in any way of sort of evening out the teams or making the prosecutor feel better by asking me some tough questions too. She clearly seemed to feel strongly about it.
Jeff's time was coming to an end, and it felt like the judges were siding together and for the opposing counsel. When I met Jeff, he was kind, polite, well off, but not flashy about it. I liked him. The moment, though, that I feel like I can most relate to Jeff Garanther is when I hear him having the same realization that I did 10 minutes ago. It's not Judge Niemeyer's job to dissect the witness interviews, and it's impossible for the state court to determine how the jury would have reacted. The circumstance that's the biggest tragedy of the entire trial, and Jeff and I both came to it separately within this episode.
Your Honor, the defense had a chance in this case, but the state took it away. They should have known about this witness. The issues you're focused on should have been decided by a jury, not by appellate judges, not by Judge Bennett, not by us standing here today. The jury has a right to hear about this, and that's all we ask for. Judge Bennett has ordered a new trial. We ask for that trial so that Mr. Nicolas can finally have the chance to present all of the evidence to the jury in a fair way.
The jury didn't think about a pink elephant because the prosecutors didn't allow that vision to enter their mind's eyes. Richard Nicolas didn't get a fair trial, and to be honest, he probably never can. I mean, it's 20 years later. Memories fade, facts get twisted, and evidence gets misplaced. As Jeff's time to speak ends, we briefly hear from Mr. Kelly one more time. He's to the point, and to be honest, his argument makes sense as much as I hate to admit it. He says, yeah, it's a shame that the jury didn't hear the witnesses, and their information wasn't given to the defense counsel. It is what it is, though, and they didn't, and we're here now, and we have to decide this case based on the current law. The law says that a factual finding by a state court can't just be overturned on a whim. That finding is much more powerful than that. Ironically, as Mr. Kelly finishes and just before the hearing comes to an end, we hear a voice we haven't heard yet. The third judge, Judge Cogburn. He makes a statement that makes me wish he would have been part of the conversation much earlier.
That's why they should always just disclose this stuff. It's just, if it's material, it's Brady and has to be disclosed. If it's not material, you've disclosed it. You don't have to worry about it. It's not going to be helpful to them, and they can spend all their time chasing that rabbit. And it's always better if this stuff is disclosed rather than prosecutors parsing whether or not to give something over.
What if everyone just followed the rules? What would that justice system look like? What did this three-judge panel decide? Right after the break. Stamps.com brings all the services of the U.S. Postal Service right to your desk, because you can buy and print official U.S. postage for any letter, any package, and any class of mail using your own computer and printer. It's easy because they'll send you a digital scale that automatically calculates exact postage. There's no more guessing how many stamps do I put on this oversized envelope, or procrastinating sending that package that's patiently waiting on your kitchen table. Really? I use Stamps.com almost every day. I imagine if I kept track of the minutes that I save by not going to the post office, and the money that I save by buying and printing my own postage, I would probably owe myself a vacation. And right now, you too can enjoy Stamps.com service with a special offer that includes a 4-week trial, plus postage, and a digital scale without long-term commitments. Go to Stamps.com, click on the microphone at the top of the homepage, and type in convicted. That's Stamps.com, enter convicted. Stamps.com. Never go to the post office again. The 3-judge panel responds to this type of appeal in writing, and the range of the response time averages 3 months to a year. I asked Jeff what his outlook was after leaving the hearing.
So I left there not feeling great about it. I think I probably spoke to you, Rachel, not too long after that. What I was then even more discouraged about was when we got the opinion a month later.
1 month is unprecedented, just like a 2-hour deliberation after a 2-week trial. Just like a prosecutor writing a thank you letter to a police officer for breaking protocol. None of it was good news. On April 27, 2016, the United States Court of Appeals for the Fourth Circuit published their decision to reverse Judge Bennett's ruling for a new trial. The opinion was written by Judge Motz, and the other 2 judges were listed as contributors. There are so many distorted facts in the ruling that I wanted to leave it out of this episode altogether. I didn't want to talk about it, because it feels like the entire case was thrown into reverse, and fact and fiction are used interchangeably, so it's impossible to even see the difference. In their decision, the judges state that the state's factual findings should stand and that Judge Bennett can't disturb their ruling simply because it's not correct. It has to be incorrect and unreasonable. And that wasn't the case. That criteria doesn't seem very reasonable to me. Additionally, the judges talk about the requirements for a Brady ruling, and they state that, quote, Nicolas argues that in rejecting his Brady claim, the state court ignored the exculpatory value of the statements in corroborating his own testimony as to the time of death. The judges declare that the witnesses' statements are, quote, immaterial because they describe a set of events completely unrelated to Nicolas's account of Asia's murder. The prosecutors then get a verbal slap on the wrist, and Richard Nicolas regains his life sentence without the chance of parole. We haven't heard from Richard in this episode. He didn't get to be there while his fate was determined. He got a copy of the court's decision in the mail a month later.
Judge Motz, when I read through her opinion, she shakes her finger at Baltimore City and says there's, that yes, what they did taints the process. Then she reinstates my murder conviction, and it doesn't make sense.
One of the first times I talked to Richard, before I ever started recording, he told me, I was sure that I was going to be home for Christmas. That statement has stuck with me ever since. Judge Bennett had given him hope. He had trusted that the system had finally worked and that he would get a fair trial. Hope is scary because when you risk hope, you also risk disappointment. So that's it. That's the story of Richard Nicolas and his journey through the legal system. Nothing about this case or this story or his trial were fair or logical or ethical. A system that doesn't allow changes because something is incorrect but not unreasonable isn't designed to seek truth, and without truth, how can there be justice? Episode 10.5, the panel episode, will be out by September 9th. Then, on September 11th, the final episode, Episode 11, will be released. And I'm going to do it. I'm going to give my opinion on innocence or guilt. But remember, it's just that, my opinion. The episode will be about Richard and so many of the things that I've learned investigating his case. But it'll be a little different because if I tell you my opinion, I need you to understand it, to see things the way that I do. I want to process the situation, the evidence, Richard's character. Most of all, though, I want you to remember that this isn't a did he do it type of story. This is a what if he didn't do it examination of the justice system and how it let this man down. I'm Brooke. Thank you so much for listening. You can see pictures, donate to Richard's Defense Fund, download the transcripts, and view other documents at convictedpod.com. The music was created by Blake Maples, and you can see and hear his work at blakemaples.com. Thanks for listening.